It's always difficult in May. There always seems to be a bank holiday around the corner, an excuse not to be at work. So thanks for dragging yourselves from your office and your clients and joining us this evening. There are quite a few people who have not managed to pull it off and so are joining us online instead, and we're glad to welcome them this evening as well. So please, can I introduce our panel for what is becoming an annual event? We had a sanctions enforcement event about 18 months ago in Chambers, just to track the level of interest in the regulators, the enforcement authorities, and in practitioners, and share our experience of what's going on and the feel for how advice is best given to our clients in a rather dynamic situation. So we've got a range of talents and disciplines on display this evening. So I'll start, if I may please, with introducing Liam Lane. Liam's an associate at Peters & Peters. He's in their white-collar team, their business crime investigations team. But I suppose his work also really encompasses just acting for wealthy people generally and their families who sometimes have to go to the police station. And one of the individuals that had to go to the police station, who Liam is going to tell us a little bit more about, is Mr. Ovsyannikov, who was prosecuted at Southwark Crown Court as the first ever sanctions circumvention case. And so we're going to learn from Liam how that case was handled at trial. Some of the issues may still be somewhat sensitive, with appeal potentially pending, so I won't probe him too much, but we can tell you that this evening all of the panelists have very kindly agreed to be on the record insofar as being quoted for anything said, and there's a recording of the event which can be made available for training if that would be useful to you in your firms and your practices. So please let us know. Next to my left, Carla Lewis is a director at Clifford Chance, and Carla advises banks, international trade organizations on compliance issues, but very much in respect of the application of financial sanctions, both in UK regimes and also in EU regimes, I think I'm fair in saying. So Carla is going to take the perspective of enforcement really by OFSI on the financial penalties regime, but also it may encompass in some of the discussion other new skills that OFSI is testing out to see how it can respond to what it perceives to be risks of sanctions breaches as in the public interest. We'll see. So on my right, taking the mirror image also of OFSI, Vansh Gupta, who is a senior associate at Fieldfisher, will tell us about his experience of trade sanctions, export controls. Vansh is a trade and competition lawyer at Fieldfisher and has immense experience working both within government and negotiating on the other side in respect of various trade restrictions. But from a sanctions enforcement perspective, what he brings to us is an extra explanation really of the new, or new to navigate for any of us because there hasn't been any interventions yet, the new actions of OTSI, so the trade equivalent of OFSI and its turf, the demarcation of responsibility between OTSI and HMRC, which has been the other two principal enforcement agency in respect of trade controls and trade sanctions. And finally, Markus, one of our very own, who had done time at, it sounds bad, doesn't it? Was formally seconded to OFSI for a period, so you can answer all your licensing queries later on over a drink. And he's going to speak to us about information offences and reporting obligations, and that might extend to relevant firms and practitioners. So obligations on us all, but also in respect of individuals caught up in their ordinary lives with new obligations that they never really have had to navigate before. Markus joins us fresh from last night's Pro Bono Lawyer Awards. We had Doughty Street Pro Bono Chambers of the Year, and Markus was shortlisted as, or nominated as Pro Bono Lawyer of the Year. So anyone who remembers life before the Legal Services General License will have some affinity with that sort of work. But for now, I would like to begin by introducing Liam to speak about the criminal perspective on sanctions enforcement.
I think that should be on and working. So yes, I acted for Dmitry Ovsyannikov. He, by way of background, is the former governor of Sevastopol, who was designated by the EU in 2017 and moved to the UK in early February 2022. Whilst he was abroad, he challenged his EU designation and was remarkably, in a landmark judgment, delisted by the European Union. The particular interesting position for Mr. Ovsyannikov was his delisting. The annulment went back to a time prior to Brexit, but the UK had obviously made a decision to autonomously list him in the UK. So he'd never been in the EU, he'd never been in the UK, but nonetheless had successfully challenged his designation in the EU with the assistance of some Spanish lawyers. He then applied for a UK passport. Now, the government has an obligation to notify designated people that they are designated under Regulation 5 of the Russia regulations. It was accepted at trial as an agreed fact that Mr. Ovsyannikov was never notified of his designation because the UK government did not hold any contact details for him. So when he wrote to the passport office and applied for a passport, and a passport was issued to him, nothing came alongside it that said, by the way, you may want to know you're now subject to worldwide sanctions because you're now a UK national with a UK passport. No, they didn't have any contact details. So a passport arrived and he then came to the United Kingdom, flew in on a perfectly normal airline, while subject to a travel ban, arrived at the UK border, wasn't stopped, was let straight through, applied to a high street bank, was onboarded and given a bank account. His wife transferred money from a high street bank account into his high street bank account, not frozen. The high street bank then gave him a bank card. He then went about spending money. And some further funds were transferred into his bank account, 3 sums of £25,000, which made the £76,000, which he was subsequently charged with. And he then tried to purchase a car because his children were in school in the UK and he needed to drive his children to school. There was a decision taken that the car would in fact be bought by someone else because ultimately there was an issue with insurance. And thereafter, he was then charged with 7 counts of circumvention and 2 counts of the proceeds of crime. One was the possession of £76,000, which when put into account was frozen when the bank realised he was designated, and the other was the expenditure of about £1,500 over a period of a month. What was quite remarkable in the case was the prosecution's case theory, which changed, as we're all probably familiar with many prosecution case theories, 5 or 6 times, was that it was a carefully orchestrated plan where they were deliberately planning to get round sanctions, which is quite difficult to understand from a defence perspective when, if you're trying to get around sanctions, you don't tend to get a UK passport. You don't tend to, when you arrive, write to the Foreign Office and say, I've just realised I'm on your UK list. I've been delisted by the EU. Can you take me off? Because the delisting in the EU occurred at a time when you were still part of the EU. And you don't walk around Clapham going into Cafe Nero and Tesco Express. And one of my favourite expenditures was expenditure of about £20 at the Lyceum Theatre, which appeared to be, when you worked it out, popcorn. But so the grand circumvention case, and I talk about it with some scepticism, and scepticism because of the evidence that came out at trial, because we had Christopher Watts from OFSI give evidence. We also had the NCA officer give evidence, who gave quite remarkable evidence. So OFSI's position was that breaches are technically criminal offences, and they wouldn't prosecute someone, and repeated the position they adopted in Khan, that they wouldn't prosecute someone if there was basic needs expenditure, but added the caveat of where a licence application was pending. And the NCA, when asked questions about sanctions, said it wasn't their ballpark, and obviously should be asked, even though they were responsible for enforcement. So it was quite an odd trial, but that effectively was the background to Mr. Ovsyannikov's case. In terms of the proceedings themselves, there was an application to dismiss litigated over the course of a full day. Tom Little, Senior Treasury Counsel, came and argued it for the prosecution. The position originally, which was quite interesting, because there was much debate about, when a client faces an issue of Regulation 19, circumvention, what's the position that's adopted? The position originally from the NCA, argued at the hearing before Mrs. Justice Cockrell, was that there was no need to have a DP in the UK. If you believe that you might be designated, then you could have circumvention take place. Or if there was a designation in another jurisdiction, circumvention could also take place. But there was no requirement for a UK DP, despite the fact that the regulations very clearly require there to be a UK DP. So we had arguments that you could have preemptive circumvention or speculated circumvention. Mrs. Justice Cockrell roundly rejected that and said that is not going to fly at all. The prosecution also tried to argue, reading between the lines, that circumvention was a strict liability offence. And one of our co-defendants' counsel quite eloquently said it would be the first time ever in criminal law that a strict liability offence uses the words knowing and intending. But that again was rejected. So the position we got to was that the prosecution had to prove knowledge, so that in Mr. Ovsyannikov's case, they had to prove that Dimitri knew that he was subject to a financial prohibition. And thereafter, there was a further argument about what was meant by financial prohibition. Our position was, if the Crown charged circumvention of Regulation 12, Mr. Ovsyannikov had to know what Regulation 12 was. We lost that argument, and the position that was left to the jury was, are you sure that Dmitry Ovsyannikov knew he was subject to a restriction on receiving financial benefit? And even on the counts where it said economic resources, that was the question that was left to the jury. So that was the position that was adopted. I could talk about many things in the Ovsyannikov case. It's been my life for the last 14 months. Yeah, I don't know if you've got any follow-up.
Well, there was an interesting insight into the home life of Mrs. Justice Cockrell, who defined circumvention, I think, by reference to, if I use paper plates to eat my supper, as High Court judges do, then I would circumvent the need to do the washing up. And that was that right? Is that fair?
That was her direction to the jury. That was her direction to the jury on circumvention.
That seems a very limited perspective on what might, to an ordinary lawyer, require some element of misconduct, dishonesty, perhaps, in terms of getting around something. Was there no element of that in her directions?
There was no element of that in her directions. There was a much, I think it was of great frustration to everyone in the case that you had simultaneously, while our case was going on, OFSI guidance coming out. That was the first time OFSI guidance had sort of said, by the way, circumvention, which previously was kind of everyone in cloak and daggers walking around setting up bank accounts in dodgy places, could now be committed by perfectly lawful routes. And I think the difficulty with our case was the difficulty and the benefit for the NCA, I think, because with circumvention and the way that the NCA believe it operates, and I use the believe it operates from the threat assessments they put out and things like that, a lot of it takes place overseas. And OFSI were very clear, and they were clear during the trial. Their main concern is financial institutions. They say they give guidance to financial institutions. The question was asked, well, where does a DP go? And that wasn't really answered. But OFSI's position is quite difficult, because unless you've got people coming forward and reporting breaches or suspected breaches, if the whole purpose of the Russia regulations, as OFSI state all the time, is to stop money going to Russia and the illicit flow of funds to Russia, you're not going to get any evidence out of Russia. You're not getting evidence out of Dubai. You're not getting evidence out of wherever it might be to support an investigation and prosecution for circumvention. And what was quite remarkable in our case, and very convenient, was of course that everything was UK based. They didn't have to worry about anything like that. So they had a simple circumvention case to prosecute on its facts and evidence. I mean, there were 140 odd agreed facts. There was basically no evidential dispute. The dispute in the case was knowledge for each of the defendants, knowledge and intent. It was factually agreed. So it made it an easier case for the NCA to prosecute, because you've also got a lot of individual entities who are between a rock and a hard place. If you're a high street bank, Halifax, being contacted by OFSI, well, you opened a bank account for a DP. Why did you? And the answer from the compliance team is, well, we saw he was delisted in the EU, so assumed he'd been delisted in the UK, which OFSI thought was perfectly legitimate for a compliance head to think.
But not for an individual.
But not for an individual.
And so a lot of the evidence must have been coming from those banks, those compliance personnel, who were themselves liable criminally for the admission that they were making concerning the opening of the accounts, etc. Have I got that right?
You're entirely correct. There was no disclosure given about what's gone on with anyone else involved in the case. There was some evidence called in respect of, so the late accounts that one of our co-defendants faced but we didn't face concerned payments of school fees, because two of the youngest children were in private schools. And there was evidence called from the person in charge of admissions, effectively from the school, who came and said that they'd actually, and this is the remarkable evidence, contacted the NCA, or the NCA contacted them in 2022, so long before all of this, to ask about the payment of the school fees. And the school said, in evidence, they'd taken legal advice and they were told there was no issue. And the NCA had said, well, if you've been told there's no issue by your lawyers, then there's no issue from us. And then in 2024, they're being prosecuted for the same payments, which they effectively said, keep on taking, there's no issue. So at every turn, you had consistently people getting it wrong. And the individuals that got it wrong were prosecuted. My client currently with a 40-month prison sentence.
Yeah.
So it becomes a bit tricky, as I say, because it felt like the whole background to it was this frenzy about there's no enforcement, there's no enforcement, there's no enforcement. And we had at the start of the trial, the prosecution served 5 days before the trial an expert report on patronage, which had nothing to do with our case whatsoever. The funds weren't said to be illicit at all. And they were trying to make it about what's gone on with the war and the invasion. And there was an attempt to make it emotional and I would say quite politicized, which Mrs. Shasta-Cockrell shut down very quickly. But it felt at times like a show trial, which I think it probably was in part, but yeah, so no,
right.
The imbalance is a bit difficult to grapple with.
We'll try and sum up lessons learned a bit later, but with a view to thinking about the position of the banks, I'm going to ask Carla a little bit later on how she might approach advising opening the bank account for Mr. Ovsyannikov. But first, perhaps you better give us a survey of what the liabilities and penalties might be for someone who gets it wrong from the financial sector.
I mean, as you said, the Ovsyannikov case is interesting from the perspective of where does that leave the lender, the other parties that were involved in that case? Because I think Halifax did actually self-report in that one. At least I read somewhere that they had.
Yeah, I mean, there was a report, but interestingly enough, it was done very late in the day, and weirdly, the first time Mr. Ovsyannikov was told about sanctions wasn't when his account was frozen. It was a letter sent to him on the 13th of March, from Halifax confirming it was sanctions, but that didn't feature in their report, even though the report was filed later. It was a very odd report. It was a very odd report that was full of mistakes, but it was very odd. So yeah.
Wait for them anyway. So from the civil perspective, it's similar position. That point you were saying about the criticism about there being no enforcement, no enforcement, no enforcement. I imagine in the session 18 months ago, people would have been saying it's coming, which is very much
Actually,
yeah, which is very much what I expect all of us will say here anyway. In the civil monetary penalties perspective, the circumstances are ripe for that enforcement to actually come. So you have OFSI's increased the size of its enforcement team fourfold since the Russian invasion happened. There's been a significant investment in technology to enable them to look at things like advanced data analytics. By contrast to the criminal position, as of June 2022, OFSI no longer has the power to impose civil monetary penalties on a strict liability basis. So if all it has to do is show that a breach after that date on a balance of probabilities did actually happen. And going by the most recent annual review, you're looking at a record number of cases currently under review by OFSI. I think they said it was something like 208 cases allocated for investigation as of April of last year. And I think you're going to see a number of those cases coming to fruition during the course of this year. Now, OFSI's position is understandable, that kind of push towards enforcement, that aggression that you're seeing there. For a number of years now, people in rooms like this have been saying that there will be this uptick in enforcement, negatively comparing OFSI to OFAC, particularly in terms of the levels at which fines have been set, the relative sharpness of the teeth of those two entities. And they've been the victim of some quite scathing and unjustified public criticism, in my view, at least. Anyway, so it's not surprising that there is this increased focus on enforcement that is manifesting in a more proactive and aggressive approach. But if you take a step back, I'm sure that everyone in the room will be familiar with the basic processes and principles and the relevant OFSI guidance that there actually is on sanctions enforcement and monetary penalties. So in essence, they can take enforcement action for breaches of financial sanctions, but that's also mandatory reporting obligations, licensing conditions, and in the Russian context, the new investment prohibitions and the Russian oil price cap. Although the focus to date has been very much on those traditional asset freezing restrictions. It can respond to breaches by taking actions with increasing levels of severity, ranging from your low-level outcomes like issuing a warning, naming and shaming, all the way up to the civil penalty itself. Cases are then categorized into lesser severity, moderate severity, or serious enough to justify monetary penalty, and then those are then split into serious and most serious. The most serious being, of course, cases that involve very high value, particularly poor or negligent or intentional conduct, or cause severe or lasting damage to the purposes of the sanctions regime itself. And then it can impose a penalty if, on a balance of probabilities, a person has breached a prohibition or failed to comply with an obligation. It's much more formulaic in approach, I would say, compared arguably with greater discretion as well, than say, if you look at a DPA from the SFO. So when they decide how to dispose of the case and the size of any penalty, there's a very clear three-step approach that OFSI will follow. So first, they calculate the penalty threshold. So that's the statutory maximum per breach of the greater of £1 million or 50% of the value of the breach. It can seem quite arbitrary in some cases when you're looking at those sort of numbers. Then within that maximum range, they set a baseline penalty matrix. So what would be a reasonable and proportionate penalty based on the seriousness of the case, taking into account the various factors that are flagged in that guidance. So things like severity, conduct, public interest. The third and final step is they consider whether a penalty reduction is warranted for self-reporting, and then they'll make a penalty recommendation. So in deciding what action to take, OFSI has said it aims for an outcome that is fair and proportionate and best enforces the purpose of the regime. Now, the current system confers a very broad discretion on OFSI, both in terms of where they set that penalty, will they set that penalty, but also when interpreting the restrictions themselves. And they have said that they will interpret those restrictions very broadly. Now, the standard allows OFSI arguably to gloss over some of the more complicated parts of the regime. You don't have the same standard and requirements that the NCA, for example, has to meet. So they can fudge, potentially, points that are more on the complicated side. So were funds actually made available to a designated person? Is a company actually controlled by a designated person? Points that are very, very difficult for corporates to financial institutions to actually grapple with or to prove the lack thereof. Now, if you look at the penalties issued over the last few years, similar to what you were saying about, oh, you have the evidentiary burden, it's based in the UK, the actual penalties that OFSI has issued have been the low-hanging fruit. So with the exception of the FCB decision in 2020, they've all been your classic asset freeze sort of example. Clearly, that's their comfort zone. Those are the provisions that they are familiar with. Those are the ones they know. All but ICSL arose from self-reporting or suspected breach reports submitted by third parties. They are on the simpler side of the spectrum, I would argue. Now, if you look at the ICSL case itself, so that was the one at the end of last year, that's the first penalty for breach of the UK sanctions imposed against Russia and the first to include a penalty imposed on a strict liability basis. If you've read any OFSI marketing material over the last few months, you will know it was the first proactive OFSI enforcement case. How they found out about it, I'm not entirely certain, but they claim they did it proactively. Now, that case was a £15,000 penalty imposed on a property management and concierge company for facilitating 26 payments on behalf of a designated person. No payments were actually made to the DP in that case. The penalty imposed was close to 100% of the value of the breaches, notwithstanding that a lot of the conduct in question was actually licensable. So it's a pretty aggressive position for them to have adopted. The other one that people here will be particularly familiar with, of course, is the HSF Moscow case that came out in March. Now, if you only read the press coverage of this particular case, the level of the fine relative to the value of the payments could seem completely reasonable. But if you interrogate it further, you can see, in my personal view at least, that OFSI really did adopt a pretty punchy position in that case. So it was a series of 6 payments made over the course of 7 days back in May 2020, which were made in the course of closing down the HSF Moscow office. Now, the majority of those related to operating expenses incurred by the Moscow office and were relatively low value. Think things like bank fees, insurance premiums, stuff like that. Concededly, there was one payment that was on the punchier side that was £4 million to the new management company that would be taking over to cover the office lease. Now, all 6 of those payments predated the shift towards strict liability. And yet the decision seems to blur the line somewhat between the parent company and its subsidiary. Yes, HSF Moscow was a UK corporate, but they're holding almost that Moscow office to a higher standard because of who its parent was. In the case, the payments were made by the Moscow finance team. They had the authority to approve those payments locally. The bigger lease payment was paid into account of a non-designated person held at Alpha Bank, which is where they fell foul. Now that account, HSF London didn't know anything about it. The decision goes to pains to make the point that HSF London didn't know anything about this bank account. And the funds, they were promptly moved out of the account into a Raiffeisen Bank account quite quickly, from what I can gather. But the fact the money was only there temporarily, it would move very quickly, that was seen as neither a mitigating nor aggravating factor. OFSI concluded in the decision that the Moscow team had no intent, no actual knowledge that the payments would be in breach of the sanctions, but they thought nevertheless they failed to take reasonable steps, and that was enough in their view to justify where the payment of what the penalty actually came out at. The breaches were also reported immediately, and the firm conducted its own internal voluntary investigation. So if you're looking at kind of that proactive cooperation, I think they did pretty well. So notwithstanding all of those factors, but for the discount for voluntary disclosure that was applied in that case, OFSI came out with the view that £930,000 would have been a reasonable and proportionate penalty for these 6 payments that happened over the course of a week. I don't know if you agree with that. Personally, I think it seems a little harsh. It goes to that point you're saying, something like enforcement is part of compliance. You need the cooperation of the financial institutions, of the law firms, in order to be able to achieve the overall objective of these sanctions. You ask, who does a decision like that actually benefit potentially? Will it have an unintended consequence potentially of dissuading other corporates who might not be in the same position, wouldn't be under a reporting obligation, to at least hesitate before they will make that self-report? I can guarantee you, I know of a case, that there will be other cases with very similar fact patterns that arose during this period. There will be cases where international parent companies had an office sat in Moscow. For whatever reason, they didn't realize UK jurisdiction would apply. They may not have realized it was an actual UK corporate due to some complicated structure. And they may not have realized that their office sat in Moscow, that may have only had a couple of people in it, carried on paying their cleaners, and their cleaners banked with the equivalent of Barclays. And all of a sudden, you're exposed to this. Now, that sense that law firms, that FIs could be doing more, could be doing better in this space, you can see that in the threat assessments that were also released in recent months. The tone of the legal one and the financial services one, it's pretty punchy. You can see in those these references to things like it's likely that the UK financial services firms have not self-disclosed all suspected breaches to OFSI. I mean, the conclusions in there, on the legal services one in particular, where they say complex trust structures are being used to hide. I mean, that's not surprising. Everybody knows that complex trust structures are being used in this manner. But the tone of the document, which seems to be suggesting law firms should be doing more, is the point in that one. The financial services threat assessment, highly likely that there will be incidents of frozen assets being improperly maintained, inaccurate assessments of both ownership and UK nexus, both points that can be notoriously difficult and are compounded by gaps in the actual listing information that you get from OFSI. Be that things like alternate spellings, which I think is one of the points that came out in, or at least it's mentioned in some of the press coverage of your case.
Yeah, there was an alternate spelling, but there was no point taken on it because there was it's the translation of his name. I mean, his name appeared the same twice, just with one with a Y, one with an I. Because obviously no one ran a fuzzy search at HBOS.
Oh, that's another issue to be moved on from. But there are problems in the listing information that you can see, be it things like that, or in some of the early ones, you were also seeing kind of incomplete banking information as well, which made with these kind of automated systems very difficult in finding these things. But it goes to that wider question of what should the enforcement priorities actually be? How does enforcement serve to establish an effective compliance regime? Now, I think everyone would agree that financial institutions, law firms need to be held accountable. They should be doing the right thing. What I'm saying is that they want to be doing the right thing. Businesses want to comply with all applicable sanctions, less from a fear of being hit with a penalty, in my personal experience, more wanting to be seen to be, well, not just be seen to be doing, but to actually be doing the right thing. And that's borne out in the act. If you actually look at the statistics of what's been coming through, in the most recent annual review, you had 396 cases, I think, recorded during 2023, 2024. 73% of those were from self-reports. The majority were made by financial institutions, about 65%, followed by the legal sector, which was about 16%. As you wouldn't be surprised to hear, most of that was Russia related. During the same period, OFSI closed 242 cases. The interesting bit of that was more than half of those were because there was no breach found at all. So you're seeing a significant number of self-reports being made out of abundance of caution. You're not necessarily getting the traction with the regulator to actually find out what happened on those. I know of a few cases where people have made self-reports and a year down the line, they haven't actually heard anything. So it can be very disruptive, not in the same sense as, oh, I can't go to the Lyceum and buy a pack of popcorn, but still quite disruptive. So I understand why the monetary penalties OFSI has focused on these types of cases. They are the easier ones to prosecute. But it would be nice to see them not swing necessarily at all of the easy pitches, to actually go for the more complicated cases out there, which I suspect are actually happening.
Just in terms of what you were saying concerning the reward for good behaviour of the professional and the castigation that we received from the threat report.
Yes.
We understand from the HSF case that there was a self-report very soon afterwards in 2022.
Yes.
And the decision was in March 2025. So that's 3 years past. What, reading between the lines, right? What's been happening? Is it OFSI double checking Herbie's homework, or what's going on?
It wasn't quick. So HSF did use its right of ministerial review. So the decision itself, I think, was rendered at the end of last year, and then it was delayed because of that process. That still doesn't explain the 3-year gap in between. I think the reality of the matter is, yes, they've increased their the size of their team 4-fold. It's still quite small compared to other regulators out there. I mean, it's about 135 people total in OFSI, something like that. It's not the biggest. I suspect they will have wanted to cross every T, dot every I with HSF. But I think it probably came down to a resourcing versus level of reports that were being made.
Okay.
I like to give them the benefit of doubt, at least.
Right. Well, we'll come back to some of the policy drivers for that, perhaps in general discussion. But I want to have the other perspective of enforcement from Vansh, if we can.
Sure. Interestingly, actually, I was working in the Treasury just when the war started in the legal division, and let's just say they were very under-resourced. These decisions, obviously, is part of Treasury, and they need lawyers to advise them on what they can and cannot do, and there's a severe shortage in the government for lawyers, if anyone's interested. Coming to trade. So there's 2 principal trade enforcement bodies today. OTSI, the Office for Trade Sanctions Implementation, which is basically OFSI's trade counterpart now, and HMRC. OTSI is very, very new. It's only 6 or 7 months old. And prior to that, all of the enforcement was done by HMRC. Now, HMRC itself is charged with also enforcing strategic export controls, which are very similar to trade sanctions, but the idea behind them is really, are our arms going to the right places? Can countries make, or bad actors in other countries make misuse of this? And I think it's fair to say that HMRC's experience and enforcement activity has traditionally been more on the export control side than on the sanctions side. Then, of course, Russia happened, and everyone started asking questions about how much enforcement is actually happening on sanctions. Then more resourcing happened. We have lots more trade sanctions now as well. And I'll take you through some statistics later on to bear that out. But what you would think instinctively that not a lot was going on is basically what these statistics show. So coming back to OTSI and HMRC and how they divvy up their functions today in terms of enforcement, I like to think that OTSI does the intangible stuff and HMRC does the tangible stuff. So if a lawyer is providing legal services that are prohibited in the Russia context, that's OTSI. If someone's facilitating goods, like prohibited goods from, let's say, Dubai to Russia, and they've never entered the UK border, that's OTSI as well. But if someone from the UK is physically sending washing machines to Russia with special chips in them so that they can be used for the war effort, then that's HMRC. Right? So in terms of substantive items, it's intangible on one side, intangible on the other. And in terms of the the actual in the regime, you have OTSI has a civil penalty regime, much like OFSI does. So the civil standard of proof, strict liability, and the same £1 million threshold, £1 million maximum limit or the value, whichever is higher. And HMRC, by contrast, does the criminal enforcement. They've for very long had powers to do what is known as compounding, like a compound settlement. And I think the closest equivalent of that is how the US does settlement agreements, where you pay a fine, and HMRC will agree not to refer this to the to the prosecutors for criminal enforcement. So there are two very different ways of approaching enforcement, and I'll start off by saying that we have no actual enforcement publicly stated from OTSI yet. So they've published a lot of guidance. They've borrowed from OFSI's manuals, etc. But there's no enforcement yet. It must be going through the works right now. Whereas HMRC's been doing enforcement on the trade side and export control side for many years now, and we have some evidence of, or rather some indications of how they've been acting, noting that the standards of proof are different, the instruments at their disposal are different. So because OTSI has not actually undertaken any enforcement yet, or made any decisions yet, I'll speak about the HMRC side of things. HMRC, I think, is more business facilitative than you would expect a regulator or whatever to be. And in our experience, they tend to be nice, right? So if you haven't deliberately tried to evade the export controls or the trade sanctions, then they try not to make a big fuss of it. And I think the desire is to not make life difficult for businesses. Interestingly, if you take a compound penalty settlement route, then your names are not published. And you also don't get a reasoned decision in the public domain. So you just get the figure and you get the reason for the penalty, but you don't get the factual circumstances. So it's only really possible to know what sort of cases there were if you've been practicing them or if you've heard from people who've been practicing them. I'll talk a bit about the staffing and how many cases have made their way through the system, because it's just useful, I think, from a bird's eye point of view, to see how these things make their way. So until 2020, there were only about 60, 70 staff dealing in HMRC, dealing with both sanctions and export control. They recruited 40 new people just for sanctions enforcement work. And I think all of the new staffing is basically because the Russian invasion has unlocked new funding in government. And you can see they've made a total of 7 trade sanctions related compound settlements so far. 6 of them have been for the Russia sanctions and 1 for the Iran sanctions. The headline one is £1 million for brokering and technical assistance. But otherwise, the amounts are fairly small. You have £1,000 penalty. You have £50,000, £20,000, nothing in the ranges that you would see as coming from the US, right? And they have the power to impose compound penalties of much larger magnitudes, but they tend not to do that. And I think it's just more pragmatism in HMRC than otherwise. There are currently 30 investigations going on into sanctions breaches. Only 1 has been referred to CPS so far for prosecution. 27 of these investigations are relating to Russia, right? And if you see how they pick up the cases, they have, like as you would expect, they get either intelligence or voluntary disclosure, or they stop goods at the border, or they get referrals from other regulators who think that something is off. So if you see I have statistics from 2016 onwards, by and large, voluntary disclosures stayed at the same level, about 200 per annum. But HMRC started stopping goods at the border more from the 2020s. So you've gone from having about 800 stoppages to 4,000 to 6,000 stoppages each year, pre and post 2020. And in terms of how that bears out in terms of compound settlements and warning letters, you have, I would say, less than 100 warning letters in any given year pre-2020. And then that starts doubling in the years after that. Similar story for compound settlements and for values, etc. So the Russian invasion has really focused more time and effort, money, into enforcing this. And the scale is still small in terms of actual fines, penalties. We yet to see what OTSI is going to do with their powers. I suspect they will look to OFSI and how much blowback they get based on OFSI's enforcement efforts of like the civil penalty regimes. I wanted to make one other point, which is that there is not that much overlap between financial sanctions and trade sanctions, because the people who conduct trade sanctions violations are not sending their goods to designated persons for the purpose of financial sanctions, right? So even though the legal instruments are similar and the regimes are similar, the characters and the circumstances are different, I would say. And that may mean eventually that you have different outcomes as well between financial prohibitions and trade sanctions prohibitions. That's what that.
Thank you. I can see a plethora of figures on your page, which you spared us some, but
yeah,
many people have picked up on the year 2020 as significant.
Yep.
Is that a Brexit phenomenon rather than a Russian phenomenon predating the February invasion?
I've tried looking into this and I haven't yet found a coherent explanation, which is I didn't offer one. So the enforcement was always with HMRC pre and post Brexit. And well, the UK leads really in the EU in terms of sanctions policy making, and I would even say enforcement. So I don't think that the difference is Brexit. Happy to be corrected by anyone with more knowledge. The double asterisk in HMRC's own submission to the Treasury Committee is that the significant increase of checks has come about from a major increase in staffing numbers and the expansion of areas assessed as at risk from 2020. I don't know why that's happened.
Okay, all right. So there are different things going on to the discussion of financial sanctions enforcement. We've got strategic export controls, which is effectively backing UK business to sell as many guns to as many people as possible, providing we know who they are and we've said yes. So providing you've got a license to do all that, fill your boots, yeah?
Yep.
And therefore HMRC are reasonably nice when it comes to dealing with that. What happens if someone does if I can use the word circumvention correctly in this context, what if someone is actually deliberately trying to send useful stuff to Russia for the worst motives?
I think that would be a right case for actual criminal enforcement, and then it would be referred to CPS and then go through the regular. I think help you guys get some time in Southern Crown Court or something.
So that's much more like
Yeah.
an exportation of, I don't know, HMRC used to prosecute drugs cases, didn't they, years ago? So it's much more like a prohibited thing.
Absolutely.
That is subject to the Export Control Order 2008 and gets prosecuted under the Customs and Excise Management Act.
That's right. So you're far more likely then to be referred on for proper jail time. But yeah, not my specialty.
And again, just digging in a little bit in the figures. So where you've got compound penalties arising from the Russia regs.
Yep.
So what is it that people are getting wrong in that situation that's causing them to have a conversation with HMRC?
So I can't speak about
Generally.
the general, like for the individual instances. I can see there's out of these 6 Russian prohibitions, 5 of them are for export, and 1 of them is for brokering and technical assistance. The brokering and technical assistance is the massive one, £1 million one. And they don't really specify the goods, they don't specify the recipients, they don't specify the exporters. So we only have the numbers and the type of offense. I suspect that the low-level ones are things that are not actively aiding the war effort in Russia, or is inadvertent, for example, because you see the logic of trade sanctions on Russia has been either to deny revenue to Russia or to deny goods that facilitate Russian industry generally, versus the goods that specifically are being used in the war itself, right? They're both prohibited, but I imagine one is seen more favorably, like more strictly than the other.
Great. Very helpful, thank you. So finally, I turn to Markus. And Markus also has a first. It's the first criminal prosecution you're defending for an information offence, which may be something you can tell us a little bit about, but not the whole story because it's not resolved yet. Is that right?
That's right, yes.
Okay.
So it seems to me that when it comes to sanctions regulators and information, there are 3 deadly sins. First, silence. Second, sloppiness. And third, downright silliness. And we've touched upon some of the mechanisms of the state already in Carla's and Vansh's brief talks, namely voluntary disclosures as a means of getting information, like the HSF case, but also the dark arts of state-led investigations, which Vansh touched on briefly. But there is another way in which regulators get information, that is by simply using the law to require it from you. And they enforce that through a tightly defined number of information offences, which, as Peter mentioned, I'm particularly interested in at the moment. These do apply across all kinds of sanctions. It's not just trade sanctions, which is Vansh's domain, but my focus today will be on financial sanctions. As Peter mentioned, I'd spent some time in OFSI alongside my time at the criminal bar, so that's going to be the focus today. I'll touch upon briefly the legal overview, the framework. Secondly, I'll go into a breakdown of these information offences. I'll thirdly discuss the prosecution sequence based on my experience, and finally draw upon some lessons from the US, which has a lot more experience when it comes to sanctions enforcement. So briefly on the overview of sanctions, it's under the Sanctions and Money Laundering Act 2018, SAMLA, not to be confused with a piece of IKEA furniture of the same name. It's Section 17(4) that enables the relevant ministers to create sanctions regimes, and specifically criminal offences. There are currently, on my count, 37 UK sanctions regimes, 2 categories within those, 29 country-based sanctions regimes from Afghanistan to Zimbabwe, and secondly, thematic-based sanctions from topics like counterterrorism and global human rights sanctions. And as far as I can tell, there are information offences across all 37 of those sanctions regimes. And I'm not going to talk about the close cousins of information offences, which are licensing offences, for example, failure to comply with conditions, or reporting offences, failure to inform the Treasury of breaches, or even confidentiality offences, disclosing confidential information under the Official Secrets Act, etc. We're just focused on the information offences, and there are 4 types. They're both strict liability offences and mens rea offences. The first is failure to comply with a request by OFSI for information or the production of documents without the defence, which is a reasonable excuse. Secondly, there's knowingly or recklessly providing materially false information or documentation in response to a request for information. So that might be silly. or sloppy, depending on the regulator's view. Thirdly, destroying documentations with the intent of evading requirements under a request for information. And finally, the broadest of offences, otherwise intentionally obstructing the Treasury in the exercise of its powers in the enforcement of financial sanctions. So going back to those country-based sanctions, the larger category, the biggest area of activity, of course, is under the Russia regulations. And it's Regulation 72 that empowers the Treasury in OFSI to request information from you. The offences themselves are under Regulation 74. These are all summary-only offences. So it's only the Magistrates' Court, likely Westminster Magistrates' Court, that's going to be dealing with the prosecution of these cases. And the maximum sentence, interestingly, remains at 6 months in prison. And it's not gone up with the general power that was provided to magistrates in October by the new government for 12 months. It's stayed currently at 6 months. And that may be of some relief to people facing these prosecutions. So if we deal with those 4 information offences, the first of which, the failure to comply with an information request, what might constitute a reasonable excuse if we draw on other areas of the criminal law? Well, firstly, some basic principles. The case of Charles, a 2009 Court of Appeal decision, suggests that a court in this context may follow the interpretation there of the Crime and Disorder Act and state that the legal burden is on the Crown and the prosecutor, but that the evidential burden is on the defendant where they have raised this evidential reasonable excuse defence. So what might be reasonable, really, according to the case law, in other areas, depends on the particular circumstances of the case. And that may include factors such as the defendant's age, background, associate's way of life, and mental illness, according to the case of the Crown against H, which is a 2009 House of Lords decision. But note, however, that mental illness does not of itself make an unreasonable excuse reasonable, but it may be a factor to go towards a jury if there was a Crown Court trial. Thirdly, and this is just my view, given the public policy interest in enforcing sanctions, and also the post-Samler deference to the state, my view, we can expect a very narrow definition of what may be a reasonable excuse when we look at these offences. Moving on to the second offence, the provision of false information to the regulator. This is the first mens rea offence, knowing or reckless. What does that mean here? Well, again, going back to ancient history, in the case of Derry versus Peake, 1889, that would be disclosure without belief in its truth, I would suggest, or carelessness as to whether the information may be true or false. Now we're getting into potential downright silliness territory, destroying documents with the intent to evade requirements. This, whilst a mens rea offence, would not, in my view, be one of recklessness if we look at the way the courts have interpreted similar offences of fraudulent evasion of duties under the Customs and Excise Management Act. So recklessness is not enough. Applying those principles to a sanctions case, you'd expect the designated person to be A, aware of the requirement to provide OFSI with information, B, to knowingly destroy that information, and C, destroy that information with the purpose of evading OFSI's requirements. And then finally, the broadest offence, intentionally obstructing OFSI in its duties. This is much broader, as I say, and it probably would encompass conduct that's captured by the other 3 offences. I can imagine perhaps some form of exceptionally unreasonable engagement with OFSI might lead to a charge in this, and I expect it to be charged alongside some of the other 3 offences. Moving on now to the timeline of a prosecution of this kind. So what does it look like? Well, we're starting really from the designation. It'd be a Foreign Office minister and most regimes that would designate a person. If it's a counter-terrorism sanctions case, interestingly, it's the Treasury that has some designation powers themselves. That designated person would then, through the post or through a friendly police officer, receive a financial questionnaire from OFSI about assets, requesting financial information. If there's no engagement, OFSI may send some very polite letters to you requesting a response. They may inform, going on to kind of Carla's territory, suggest that you are now civilly breached sanctions before ramping it up to requiring you or inviting you to attend a voluntary police interview or even arresting you before charging and then appearing at the Westminster Magistrates Court. In terms of prosecution, Liam touched upon his case being prosecuted by the National Crime Agency. My terrorism case is being prosecuted not by the National Crime Agency, but by the CPS Counter-Terrorism Unit. So they are drawing upon their adjacent expertise in that case. And finally, some lessons from the US. There are two cases from 2019 that I thought quite interesting and really illustrate some of the silent sloppiness and downright silliness potentially when it comes to engaging with regulators. First of which is a Florida-based company called Southern Cross Aviation. They were issued with a civil reporting violation for failing to provide complete information around the sales of helicopters to Iran. And they considered these to be the aggravating factors in that case, which are to be avoided at all costs. A demonstrable recklessness regarding the US sanction requirements by failing to provide accurate and complete information in response to a subpoena by OFAC. Evidence to suggest that Southern Cross had actual knowledge or reason to know of the conduct that led to the violation in this case. And finally, quite simply not cooperating with the regulator as part of its investigation. A second, much more serious case, which was issued by OFAC on the same day in 2019. There was a company called D&I Express Shipping, and that concerned a civil reporting violation for providing OFAC with contradictory, misleading information, incomplete information regarding its shipping of farming equipment to Sudan. It deemed the following to be aggravating factors in that case: a reckless disregard for US sanctions requirements by failing to provide accurate and complete information in response to OFAC subpoenas, the provision of false, materially inaccurate, materially incomplete, misleading information regarding the actual shipment of goods to Sudan, and a failure to correct original false responses and instead confirming them in their correspondence, and generally not complying, not cooperating, I should say, with OFAC's investigation. And just to end, what's interesting is that OFAC broadly highlights some lessons learned in both of those cases that I would suggest are quite useful in the British context as well. The first of those being, which hopefully is quite obvious, is the importance of cooperating fully with OFAC or OFSI in this country regarding investigations. The importance of diligent reviews of information, documentation in response to OFAC subpoenas. The first case was a case where OFAC penalised them not getting it right on the first go and having to issue a second subpoena. And being really accurate in your response to OFAC, to be complete in the information you provide and providing that in a timely enforcement action. So hopefully, if you do all that, you won't have to be represented by me.
Thanks, Markus. There have been very recently 3, I think, disclosure notices that were issued to NGOs and charities working in the occupied territories, essentially. I had a client as well that got caught up in this, but we persuaded them not to issue a disclosure notice because they were very keen to know who was potentially going to come foul of the Israel regulations and the OPT. In those instances, a lot of commentators remarked on these are organizations that are not set up like banks. They don't have the resources to draw upon, nor do they have, a team of lawyers to advise them to get this right. Maybe it's just a messaging process that OFSI are engaging in, but it did seem to be a fairly disproportionate outcome for those institutions that were trying to do their best. Do you think there's a problem of scale sometimes with these obligations?
Yeah, I definitely say there is often an imbalance in terms of the resourcing on some level between firms and government departments trying to enforce these sanctions. And of course, you have to see it in the context of pre-Russia war, post-Russia war as well. As Carla mentioned, there's been an upskilling and a recruitment drive, etc. But on the other hand, the state does have access to useful information already of its own to enforce these sanctions. And that's an important factor to consider as well, given what I've said, without its laws, given the powers that it has, it's the intelligence services it has. You have to look at the OFAC cases as well. They're suspicious about things before, a compliance officer in an aviation company in Florida can say, oh, there's no Iranian helicopters being sold here, and OFAC coming back and saying, oh, yes, there are.
Yeah.
How do they know that? It begs the question. So I think hopefully that's a balanced view. What I'd like to see in the future is a more an American approach in dealing with sanctions enforcement and being cooperative and much more dialogue, face-to-face encounters. I think that would be a way of enhancing public trust as well in the enforcement of sanctions, and hopefully leading to fairer outcomes that you can trust rather than just reading from a press release on LinkedIn or something.
Yes, we have been perhaps doubting the motives of the enforcement agencies more than once. We started a little late, and so I don't want to keep you here later than you'd wish to be, but it might be that there are some questions from our audience that you'd like to put to the panelists. And if so, Ray is here with her handy microphones to help you out. Here's one from Andrew.
Yeah, thank you very much. I've got a question really about trade sanctions, so probably more for Vansh, but for anyone, that it used to be the case pre-OTSI that if there was an HMRC investigation, you would just try and push it down the compounding route, because as you said, then there's no publicity, they're not named, no one knows anything about it. But now OTSI has the power to issue civil penalties, which, like OFSIs, will include the name of the company and details about it. So I don't really understand why, if there's a breach now, the HMRC and OTSI would be using compounding anymore. Wouldn't everything just be handed over to OTSI so that they can publish a damaging notice in the way that OFSI does? So in other words, is there any future for compounding?
I already have that. I think yes, because OTSI's and HMRC's roles are not overlapping. They've tried to segregate them. So HMRC still deals with some trade sanctions related problems. That's one thing. The second is that OTSI, I believe, can choose to not publish names. So if they wanted to not have, if they thought it was disproportionate, they could issue a private warning letter and then not publish the name of the company, thereby preserving their reputation. So there is still, I would say, an element of large discretion left to whichever enforcement body it is, to not name and shame.
And the proportionality of publishing is a lever that can work with OFSI. You have to show real consequences, I think, and prejudice to the entity involved. And it might be more difficult to do where in a trade context there's money being made and the public interest might be higher for disclosure. But it'd be interesting to see how that pans out. Would anyone else like to ask? I have a question myself. We have a lot of discussion in the press about trade with the US, and so much of what goes on in terms of policy making and implementation seems to be hand in hand with the US. Do we detect a change in the weather that might affect enforcement actions by UK? Are they going to get less intelligence from the US? I use that word advisedly. But you know, there may be a risk that they're just not fed the leads to pursue. Is that something that might arise?
It's an interesting question because OFSI and OFAC have had a very close relationship for a very long time. I mean, you have the secondment program in place. There is cross-sharing of information, all that kind of stuff. You may have less information coming from the Americans, but I don't think that would necessarily have a significant impact on enforcement, because I think a lot of the enforcement information is coming from self-reports. It's coming from suspected breach reports from third parties and mandatory reporting, all of that kind of stuff. You have the focus today has been very much on the UK piece. You haven't been seeing very much cross-border type of enforcement. So not necessarily. I've kind of seen it more from the other perspective of, like it or not, at the moment, the US is a bit of a black hole in terms of what's actually going to happen on a lot of these things. There's a lack of legal certainty, lack of predictability as to where the policy will actually go. In part, I think that's intentional. I have my own personal views, but I'm not going to go into those. So I do think you're going to see more of an alignment between the UK and the EU in terms of their enforcement priorities. I think the EU and the UK have made their position on Russia in particular very clear that they are going to hold fast. They're not going to scale back everything until you reach a world where Ukraine at least are definitely involved in the conversation and the EU are happy and the UK are happy. So I'm optimistic. I don't know if you can be optimistic about enforcement. Yeah,
Okay.
but yeah.
Thank you. Anything from the trade side?
I think at least in Europe, the UK is seen as a guiding light on sanctions. Before we left the EU, the UK held the sanctions lead within the EU and provided a lot of policy making support, intelligence, etc. To do it. I think post the American, let's call it parting of ways, the UK still has, I would say, quite a lot of capability in at least formulating the policy around it. I think on the trade side, it could affect intelligence in terms of where the flow of illicit goods is happening, and therefore which entities you should be raiding, etc. But as Carla said, if there's a voluntary disclosure, that shouldn't be an issue. I think OTSI has a particularly difficult job because they don't deal with tangible things that you can stop at the border and check if they're the right thing. They have to rely on intelligence, so it could affect that bit of the job.
Just on that, Peter, I had a very useful exchange with a colleague in the States about this topic just a few days ago. And according to them, it seems that the US administration is focusing more now on individuals rather than corporations in terms of its enforcement prioritization. And on a second point, it seems to be quite interested in the crypto industry, which might not surprise people. But it seems that they are really interested in deregulation of the crypto sector, but also less interested as a result, potentially in enforcement around the crypto industry and circumvention. But as to whether that will impact us here, I think there was a former member of Chambers who handed a golden envelope to the president recently, who said, you know, there's a potential second state visit here for you, if you like. And I could expect that a bit of diplomacy and dazzle might, you know, help OFSI and others in its enforcement of sanctions if they're bold enough to do so.
Okay, self-reports in a golden envelope. You heard it here first. That's the way forward. May I invite you to join me in thanking all of our speakers who've assisted us in better understanding